Uh-oh, Lindsey Halligan, it's not looking good for you. Donald Trump's top federal prosecutor in the Eastern District of Virginia, Lindsey Halligan, is in deep, deep trouble. And there's nothing that Pam Bondi or Donald Trump can do to try to save her. Just a reminder, she's Donald Trump's former personal lawyer. She was a beauty pageant contestant turned insurance lawyer with no federal prosecutorial experience. She worked inside the White House in this Trump regime. And then when nobody wanted to bring federal charges against former FBI Director James Comey and New York Attorney General Letitia James, because even Donald Trump's Republican United States attorneys and interim United States attorneys said that the claims against them have no merit and would be utterly frivolous, Donald Trump posted that message saying, Pam, referring to the Attorney General, Pam Bondi, we need your help. Go after my political enemies. Apparently that was supposed to be a direct message to Pam Bondi. Regardless, we all saw it. Regardless, that's not ethical and normal behavior. And it may be unlawful behavior. Let me be clear about that. So then Lindsey Halligan stepped in. She was the she became, or at least anointed, probably unlawfully, as the interim United States attorney for the Eastern District of Virginia. Again, with zero prosecutorial experience, she goes into a grand jury all alone, the grand jury room. Nobody's with her. And just remember this, she's never done a trial before, yet alone a federal criminal trial, yet alone been in a grand jury. And the stakes don't get higher than this. It's not a bigger case than this. James Comey, the former FBI director. And then she secures an indictment. There was some weird procedural stuff, though, with the indictment. There was one version of the indictment that had 3 counts that the grand jury seemed to reject. But then there was another version of the indictment with 2 counts that the grand jury, and it was a very close vote, seemed to be okay with. And the foreperson apparently signed their name. And so then James Comey was indicted. But you know, here from watching the MeidasTouch network and watching the videos I do with Harry Litman of Talking Feds and the Legal AF videos, I said, I wonder what Lindsey Halligan was actually saying in that grand jury room, because something that you may not realize about grand jury procedure is that the judge is not in the room with the grand jury. The person who's the target of the indictment, who could become the criminal defendant, they're not in the room. Their lawyer's not allowed in the room. So it's just the prosecutor and the grand jury, and that's it. And oftentimes these proceedings, not oftentimes, mostly always, are shrouded in secrecy. And we really don't even know what happens unless that witness who's at the grand jury's called to testify. So the procedure would be Halligan would pick probably an FBI agent or someone who would testify upon information and belief what they believe the crimes were committed, to determine if there's probable cause to get to the next step and to have this indictment ultimately get filed. Lindsey Halligan, as the lawyer or who's ever in the room, would be asking questions to that FBI agent. The prosecutor would be then giving the instructions and the law to the grand jury and ultimately ask the grand jury to issue this indictment. And so what I had been saying, what Harry Litman, former top federal prosecutor in Pennsylvania and at the DOJ, what we've been saying a lot is, what the hell did she tell this grand jury? Because we knew who the potential witness number 3, the key person in the case, who is supposed to corroborate that Comey lied to Congress. McCabe was on the MeidasTouch podcast. The other guy was Comey's lawyer and friend, and we've seen their testimony before in other settings. They corroborate Comey. They don't incriminate Comey. They're exculpatory. So I'm like, how could that be helpful to Halligan unless she just lied to the grand jury when the judge wasn't in there and when the defense lawyers weren't in there? So one of the first steps that Comey did was challenge Lindsey Halligan's authority to be a federal prosecutor in the first place, to serve as an interim United States attorney. Because under the appointments clause of the Constitution, and then a kind of a law that deals with the appointments clause, the president of the United States is allowed to pick one and one only interim United States attorney for a finite period of time. And then after that period of time expires, they either need to be confirmed by the Senate, there could be an extension by the federal judges in that district, or the federal judges can say, we don't want this interim anymore. And then they basically pick the replacement, and that becomes the person for all purposes. So the interim United States attorney in the Eastern District of Virginia was fired or pushed out by the Trump regime because he saw no evidence to go after Comey or New York Attorney General Letitia James. So that was the one interim that Trump was allowed to pick. So then when you had Lindsey Halligan step in, and she was the only person in the grand jury and the only person from the federal prosecutor's office who signed this indictment, after the grand jury, agreed to this indictment, she was unlawfully appointed, so she was not allowed to be in the room. And that was the last day of the statute of limitations. So if she wasn't authorized to even be in the room and the statute of limitations expired, then that's why Comey's saying dismiss this case. It's a long-winded way of saying that the judge then transferred, for purposes of disqualifying Halligan, which could result in a dismissal of the case, the disqualification of Halligan issued to another judge named Judge Curry. Judge Curry says, let me see the entire grand jury transcript. I want to read it. It was curious because we're like, why does this judge want to read the full grand jury transcript? Isn't it enough to just know that Halligan was the only person in the room? Couldn't you just deal with it as a request for admission? So Harry Littman and I, you'll recall, weeks back, we were like, that's interesting. I think this judge realizes where this is going and wants to be a few steps ahead and wants to see what really went down in this grand jury room. So the judge said, I want to see the entire grand jury transcript. But the thing is, Lindsey Halligan the other night turned over just a small portion of the grand jury transcript, not the portion where Halligan introduced the witness or spoke to the grand jury at the beginning, not the part after the witness left, and not when Lindsey Halligan gave the charging instructions to the grand jury. All of that was deleted, omitted, hidden, whatever it is. It wasn't submitted to Judge Curry. So Judge Curry said, what the hell are you doing? By today, by November 5th, I want to see the full grand jury transcript. Give me everything, Lindsey Halligan. What is this? So Lindsey Halligan now has to turn over these other portions. And the question is, what did she tell the grand jury? And the judge was exactly what Harry Littman and I predicted. Harry, I'm so sorry I went so long. I guess because of this court back room here, I felt like my trial lawyer days, like I was giving up my opening statement. But I wanted to frame all of those issues because I know this stuff can get complicated and complex because of all the violations Trump's committed. But I guess the bottom line is that Lindsey Halligan could be in deep trouble here, depending on what she told the grand jury. Take it away, Harry Littman from Talking.
Yeah, well, so first, Ben, look, it's good you did, because this is a tangled web legally and a tangled web factually. But to cut to the sort of high points, first of all, Lindsey Halligan walking into a grand jury when she hasn't spent a day in federal prosecutorial office at all is like a paranoid nightmare out of Alfred Hitchcock. Just thinking about it, AUSAs, they're trained for a couple years, then they go into a grand jury, but there's somebody else with them. And, as you say, she's not only auditioning on Broadway, or you're going right into the play, but it's at a very, very high level. And in addition, it's not just a high level, but it's a situation where she's been told, in effect, by Trump and Bondi, get me the scouts of Jim Comey and Letitia James. So she's all alone in there and trying to do it. What is in that transcript could be really just chock full of the evidence of what is true, which is her amateurishness and eagerness to bring home the body, as it were. Now, how would it work? You're right. First of all, second of all, sorry. So telling and ham-handed that the response to Curry's order, give me everything, is, oh, here you go. Oops, just no Halligan stuff. And obviously they don't want him, much less the public, to see it. And I think we're gonna, he said, give it to it right away. will the administration try one of its gambits of emergency, go up to the Fourth Circuit to try to prevent it? That's still, within the realm of possibility. Going back, though, to what probably happened, you're right. She probably put on an agent. And in a typical situation for an amateur, like a bank robber, you could say to the agent, just don't worry, Lindsey, just say, what happened next? What happened next? But remember the core charge here that Comey gave a false statement, and it's a very convoluted question to set it up from Senator Cruz, and a very tricky. His answer is, I stick by my testimony in 2017. She's going to have to have asked that person, well, was that false? Why was that false? And of course, as we know, Comey's just filed a motion saying it wasn't false at all. It was true. He did stick by his testimony. In other words, it's going to be a little bit harder than a normal, straightforward grand jury where you can just ask the FBI agent or whomever to sort of give hearsay after hearsay and walk out. She's going to, I think, have had to sweat it a little. Third, big point. They not only, I didn't see this at first and credit, I'm forgetting the great person on the web, but sometimes it's full of insights. You know who I'm talking about. But the charge is that it was false because he was asked, did you ask anybody in the FBI about maybe coordinating with the press? And he said no. And the brief that the U.S. has filed today goes on and on with these comments and colloquies they've gotten between him, Comey, and his buddy, Dan Richman, a professor at Columbia and former colleague. And really, it's got nothing to do with the motion. They lead off with it kind of to just make them look bad. But talk about look bad. Many of the conversations that they quote happened after Richmond has left the FBI, and they don't mention it. So it's completely non-responsive to the supposed false statement, and it's just, really a low blow. And then the other stuff in there, I could do it anyway, or we have a new filing by Pam Bondi saying she appointed Halligan to be a special attorney, and it's all really feels very, very flailing. And then they get to, I think, what's going to be the core question of the remedy. And finally, before punting it back to you, because this is something you and I have been on and talked about from the start, given that what they basically say, which is, okay, so Trump said these things, but you don't have direct evidence of reprisal. I mean, I can't imagine how it could be stronger, but the table is very well set for Nachmanoff to order discovery. You've got a strong inference evidentiary conflict here. Comey has asked for it. It seems to me at a minimum, if he wants to credit what the U.S. is saying, he does something that's very unusual for this kind of case and very, I think, potentially embarrassing for the administration, which is, I want Bondi and Halligan, maybe even Trump, to tell me what the hell happened so I can judge whether it was really done as a matter of reprisal. And that's going to be something they'll fight tooth and nail, but I don't see how they get out of it. You really need this evidence. And we know executive privilege, et cetera, is a conditional kind of privilege to proffer. So that's going to be a really hard fought, colorful kind of battle coming up and soon.
Because we love to load these videos up with data and documents and get into the weeds, let me show what that document looks like that Pam Bondi filed a day or two ago, where she purported to retroactively appoint Halligan under a different statute and then ratify her grand jury presentation and signature on the indictment, as Roger Parloff says, a month after the statute of limitations ran out. It doesn't work this way. Yeah. And even the way Pam Bondi framed the issue, she goes, for the avoidance of doubt as to the validity of the appointment of Halligan, and by virtue of the authority vested in me as the Attorney General,
Sounds
I
like Wizard of Oz, doesn't it?
I hereby appoint Ms. Halligan to the additional position of special attorney as of September 22nd, 2025, dated 2 or 3 days ago. It doesn't work. You don't get to go back in time and do it that way. Just the mere filing of that document is humiliating. So I wanted to show that document, but I also wanted to show this one because we've been speaking a lot about Halligan's behavior as it relates to Comey. But what about as it relates to New York Attorney General Letitia James regarding the vindictive prosecution discovery? The judge in the James case says, as part of your discovery obligations, federal prosecutors turn over vindictive prosecution related documents in your initial disclosures. It was an order by the court. Then the Department of Justice filed this. Have you ever heard of this filing before, Harry Littman? This is what Halligan's team filed. Government's notice of reason not providing pre-vindictive selective prosecution motion related discovery. And then it goes on to say the requisite showing by New York Attorney General Letitia James had not been made yet in terms of an affirmative motion before, Judge, you ordered this vindictive prosecution motion. We need to go through the process that we saw in Abrego Garcia's case. We all see how this comes together for people who watch this in the Middle District of Tennessee, where Abrego Garcia filed an affirmative motion, find the threshold finding of vindictive prosecution, and then I'll get the discovery and then make a ruling on whether or not to dismiss it. What the government's saying is we still need to go through that Abrego process right here and determine if that threshold issue is made. You know, where it seems like a prima facie claim is made when Donald Trump posts, hey, Pam, go after her, Pam. That's never happened before. But Harry, what do you make of that? And notice of not following your order, Judge.
Right. I mean, this is so of a pattern, Ben. They come out with these outrageous, and they did it, in fact, with Abrego in the criminal law case. They come out with this really, I think, often PR kinds of stunts and filings, and then the law intervenes, and it's like, oh yeah, I appointed her, and she had de facto authority. And by the way, I mean, this specific thing, what do I make of it? It's another way of saying, we're defying your order. Judge Nachmanoff is perfectly as authoritative to decide what discovery he needs to decide a motion. That discovery, by the way, would likely be in camera, so there's no issue. He said, give it to me, and they're now instructing him on what he didn't find. You know, he is, I think, a thoughtful and, by reputation, mild-mannered guy. Some judges would absolutely hit the roof at that, but what they're saying is, we don't want to. And we'll see how far they take that. Remember with Abrego, if he says, well, I thank you very much, but I ordered it and have it within an hour here, please. Will they then run in, to the court above, again, the Fourth Circuit for Nachmanoff? But, all of these things that happened with Abrego, with all the things they were trying to hide about Bove and the basically improper things he said, and we've now had even a clear demonstration of that. Many people have come forward. It's the same thing. They play dirty and violate the Constitution, then proffer some motion and say, but you can't ask us about that. There's no reason that they can't. And look, I don't see how even a higher court would, they maybe the U.S. has to withdraw the case or whatever, but unless Nachmanoff's just going to say, fine, it's a reprisal prosecution, I so hold, case dismissed, without even hearing the evidence, it's got to be heard. There's no way for him to say, I don't have to hear the evidence and I can dismiss this all. It's just too strong, as you say, a prima facie or initial showing. So that showdown is coming, and it's just, again, they play dirty behind the scenes, and it's very relevant to what happens, but they want to conceal it. And so we have not just that, but also all the things that not just the communications that led to the indictment, but everything Halligan said in the grand jury, which we can only assume right now are fairly embarrassing. And, now the fight's going to be to get that information out of the U.S. Case is strong to get that information out of the U.S. unless the U.S. is just going to fold its tent, which, by the way, you and I predicted the case will never go to a conviction, and that it will be really bad and a black eye for Halligan, as you say. Of course, I don't know if Trump really cares. He's gotten his pound of flesh and made things miserable for his antagonists, and that he might just somehow declare victory and move on, right?
Well, right. I mean, when Trump loses these cases, the $1 billion lawsuit here, the $1 billion law, there was another one where I think Truth Social, Trump Media sued all of these companies 2 years ago for bajillions of dollars or whatever it was for how they reported on the finances. And it just got dismissed the other day. And did anybody ever hear that got dismissed? No. You heard the headline, 20 billion, $10 billion. That's what he wants. He raises all this money off the lawsuit. So you sanction him $1 million, $10 million. For him, he got his headline. It's a PR tool. But anyway, there's a whole other hot take for that. We covered a lot, Harry Litman. Now, everybody, you need to subscribe to Harry Litman's YouTube channel, the Talking Feds YouTube channel, the Talking Feds podcast, and the Talking Feds Substack. I don't know, Harry. I think as I'm in this courtroom, I'm fired up in a different way today. Exactly. I just different vibes for me. And hit subscribe. Hit subscribe.
Mr. Meiselas, you seem to be dressed casual for court today, but
exactly. You know what?
You can dress casual when you have such fine advocacy skills, I suppose.
Well, if you're not working for this current DOJ, you get sanctioned. If I would show up 30 seconds late to court back in the day, I would get one of those $1,500 sanctions and have to explain to the law partners it only happened once. It'll never happen again. Hit subscribe. Thanks everybody for watching.
Thank you.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.